and commerce of the petitioner because the demand order is misconstructed as it is based on an erroneous assumption. And such misconstructed order will essentially hinder the freedom of trade and commerce of the petitioners. Your Lordships, there's another submission regarding alternate remedy which further dwells why such right is hindered.
No, what I'm saying is 19(1)(g), you are saying an order is misconstrued, show cause notice is the result of misconstruction of provision, etc., etc.
Indeed, Your Lordship.
Does it violate 19(1)(g)?
Indeed, Your Lordship. Lordship, the show cause notice in itself does not violate 19(1)(g). It is the demand order that is based on the show cause notice that violates the right of the petitioner.
Do you have any authorities for that?
Your Lordship,
if a demand is made without jurisdiction or without by misconstruing the provisions, it should tantamount to, it shall be construed as tantamounting to violation of fundamental right under 19(1).
Your Lordship, it is the case that I referred to. It is the case of Srimati Ujjambai versus the state of Uttar Pradesh, which was a 7-judge bench of the Supreme Court, which decided.
The one you just referred.
Indeed, Your Lordship.
Where is the reference to 19(1)(g) there?
Your Lordship, I think the reference to 19(1)(g) has not been added because it was about the misconstruction of the notices that has been added.
All right, you may proceed further.
Much obliged, Your Lordship. Your Lordship, continuing with Article 265, no tax can be collected or levied without the authority of law. Reference is taken from the case of Joshi Technologies, where it was held that any collection of tax without the authority of law is tried in law. It was a case regarding the wrong refund of taxes. If the Lordships may have page 84 of the compendium provided. Realization of tax on money without the authority of law is banned under 265 of the Constitution. Octroi cannot be levied or collected in respect of goods which are not used for consumed or sold with the municipal limits. So these amounts become collection without the authority of law. Your Lordships, any collection of tax without the authority of law, as in the present case, is bad in law, and such the respondent cannot do.
No, how do you say it is without authority of law? Applying the principles depends on the facts and how you put it across. We are in agreement, respectful agreement with the propositions of law laid down. Indeed. They are binding precedents. But then how do you say this tax is levied without authority of law?
Your Lordship, the essential submissions are that the respondents have issued the show cause notice without jurisdiction. Furthermore, there was no taxable event which has occurred for for tax to be levied under GST, and that too under Section 7. There should be a taxable event which has occurred. There was an bona fide employer-employee relationship between the petitioner and what the respondents essentially considered as seconded employees of the petitioner. So no tax can be levied on an employer-employee relationship. It is out of the purview of GST liability.
How do you demonstrate that it is a bona fide agreement?
Indeed, Your Lordship, we have gone through multiple tests that have been provided by the Apex Court. My co-counsel will deal at length with the tests in her issue. But if the court, if the Lordship so want, I can brief them about it.
No, all right. If you have her there to address that, we will reserve that question for her.
Indeed,
but you have to explain to us, how do you say that this arrangement is bona fide, as you are trying to put it, and that they are your employees, directly your employees, and they have no connection at all with the overseas people who are stationed there, entrepreneurs who are stationed there, who have supplied you these people initially, whom you feel they are, now you make them as, absorb them as your, all right, you proceed.
Much obliged, Your Lordship. The counsel further.
Yeah.
See, you're saying the first question is with regard to the jurisdiction.
Indeed.
You are submitting that the authorities did not have the jurisdiction.
Indeed.
What exactly do you mean by that? You mean to say if all the notices, let's assume it's not the tax authorities, any authorities for that matter, under a statute, if they issue notices, a demand notice, then the question of that they do not have the jurisdiction. How are you questioning the very jurisdiction? If that is so, did you exhaust all your statutory remedy available to you before invoking the jurisdiction?
Essentially, no, Your Lordship. And Your Lordship, the submission that I'm coming to right at the moment is about efficacious and effective alternate remedy and how that is not a bar to filing a writ petition before the
Because your
Honorable Court.
entire submission in the first beginning itself is that it is violating the
Jurisdiction.
fundamental rights,
Indeed,
right?
Your Ladyship.
So the
Lordship.
same way, the authorities are also duty bound to do that. So they are issuing a demand notice. So how can you outrightly say that they do not have the jurisdiction?
Uh,
They are doing under the law, they are doing under the statute, where they have been empowered to issue notices and to collect their taxes.
Your Ladyship, it is Lordship. Pardon me, Your Lordship. Your Lordship, it is provided in the very statute itself that a proper officer must have a reason to believe before issuing a show cause notice. In the present scenario, and in the show cause notice itself, the proper officer must provide evidence as to saying that there was a malified intention on the part of the assessee for not paying the tax.
So what was your next course of action after the receipt of the demand notice?
Your Ladyship, there has been Your Lordship, there has been a demand notice, and we have filed a writ petition against the SCN itself. That is a very next move, Your Lordship.
My question was whether you have noticed exhausted the remedy available to you, statutory remedy available to you before invoking the writ jurisdiction.
Essentially, not, Your Lordship. However, I have an argument in relation to that, if I may pursue.
Please continue.
Much obliged.
Just to be clear, are you challenging the show cause notice or the impugned order assessment?
The show cause notice, Your Lordship.
How can you challenge the show cause notice after having replied to it?
Your Lordship, it is provided in the.
You have submitted to the jurisdiction, isn't it? Once you reply to a show cause notice, you accept that that particular officer has jurisdiction. Then how could you subsequently take an alter ego and now challenge? On one hand, you have replied to it, and now you are saying that the show cause notice itself is invalid. Okay, how could you do both at the same time?
Your Lordship, if it was on the council would have challenged the demand order itself. However, it is present in the Moot proposition that we have to raise the issue of the maintainability over the show cause notice itself.
No, now, regardless of the facts, now
Indeed.
that what is being challenged here, is it the show cause
The
notice?
show cause notice, Your Lordship.
So where the proposition, does it say that you're challenging the show cause notice? It's against the demand order that have approached this honorable court, right?
It is the show cause notice, Your
Notice,
Lordship.
okay.
If I may go ahead, Your Lordships.
No, I think counsel, you have to go to para 15
Indeed, Your Lordship.
of the facts.
I think, Mr. Counsel, you need to be slightly clear on what is the challenge you have.
Yes.
Yes.
No, read para 15.
Indeed, Your Lordship.
What does it say? Can you be loud, please?
Against the demand orders, the Indian company filed 2 writ petitions before the High Court of Karnataka.
Why would you say show cause notices?
Your Lordships, it is.
Are you clear? Is it? No, okay, instead of making it argumentative. So you have challenged the orders, right? Are you clear? Do you
Indeed,
accept
Your
that?
Lordship.
Yes, it's not this show cause notice.
Indeed, Your Lordship.
Now answer the question. Why would you reply to the show cause notice and now challenge it?
Your Lordship, I will go back to my initial argument and raise the legal maxim because the base itself has fallacies. The show cause notice themselves are fallacies. Then the superstructure itself has fallacies, and so do the demand orders. The council does stand corrected that the demand orders should have been challenged in the writ petition.
Yes, that's what which has been challenged. But I think you misunderstood as if the notices have been challenged. The facts are clear. It says against the demand orders.
Indeed,
The
Your
notice was issued. You gave a reply against which an order was passed. Now we are before this honorable court.
Indeed, Your Lordship.
Okay, fine. You can proceed.
Much obliged, Your Lordship.
No, are you trying to say that what a service provided by an employee to you,
Indeed.
seconded employees,
Indeed, Your Lordship.
are not either goods or services?
Indeed, Your Lordship.
And since it is neither a supply of goods or services, the jurisdiction for the respondents to issue a notice will come only if there is supply of goods and services.
Indeed, Your
And
Lordship.
since there is no supply of goods and services, and therefore they have no jurisdiction to issue the notice. Is that what you're trying to say?
Indeed, Your Lordship.
Go ahead.
Much obliged, Your Lordship. The council further submits that the existence of an effective and efficacious alternative remedy is not a bar on this honorable court's power to entertain the writ petitions. It is tried in law that the bar of alternate remedy is a self-imposed restriction by the courts on the exercise of their own powers, and the said bar is a matter of discretion which can be exercised in the right facts and circumstances. Your Lordship's reliance is placed on the decision of the Apex Court in Whirlpool Corporation. If Your Lordships may have page 8 of the compendium provided. The very first paragraph, Your Lordships. The fifth line. Where the writ petition has been filed for the enforcement of any fundamental right, or where there has been a violation of the principles of natural justice, or where the order of proceedings are wholly without jurisdiction or the bias of an act is challenged, in these extraordinary circumstances, a writ petition can be entertained even though there's an alternative, effective and efficacious remedy. As the council has already constructed that there has been a violation of fundamental rights and there has been an excess of jurisdiction. However, Your Lordships, even the effective and efficacious alternative remedy which is provided is not very efficacious in itself. Your Lordship, the council is referring to section 107, subsection 6, B of the CGST Act. If the council may read the section aloud. Much obliged, Your Lordship. The section says, Your Lordship, a sum equal to 10% of the remaining amount of tax is disputed arising from the said order, subject to a maximum of 25 crore rupees, in relation to which the appeal has been filed. Your Lordship, when there has been no taxable event, when there has been no liability on the petitioner itself, why do they even need to pay this 10% amount? And Your Lordships, there's also a problem. The respondents contend that the petitioner could have gone before the GStat. However, the GStat has not been set up yet as of it. So the only remedy, alternate remedy which is provided to the petitioner is go to the proper officer, which is the commissioner. And even if the order of the commissioner hinders or violates any rights of the petitioner, he cannot go to the GStat because all the proceedings of GStat are stayed as of it. And therefore, this writ petition should be maintained.
According to you, the tribunal is not yet constituted.
Indeed, Your
In the
Lordship.
absence of the tribunal, the only remedy is to approach the honorable court.
Indeed, Your Lordship. If I may proceed with my
Yes.
much
Yes,
obliged.
this order, you can go to the first appellate authority, right?
Yeah, the first appellate authority being the commissioner.
You can still go there, right?
Yes, Your Lordship. However, Your Lordship, even that alternate remedy and the stipulations which I provide in extraordinary circumstances, seeing both of them in fact, the writ petitions are the best alternative for the petition in the present case.
No, if the first appellate remedy is there,
Indeed, Your
then
Lordship.
non-constitution of the tribunal pales into insignificance.
Pardon me, Your
Can't say
Lordship.
Non-constitution of the tribunal pales into insignificance if you have had the opportunity to go before the first appellate authority.
Indeed, Your Lordship. However, there are these special circumstances where
All right, that may not be a very valid ground is what. The first ground may be a valid ground. No jurisdiction, violation
Your
of
Lordship.
fundamental right. Without jurisdiction, he violates. As my brother put it, it doesn't fall within the parameters of the law itself.
Indeed, Your Lordship.
Service tax doesn't apply at all.
Indeed, Your Lordship.
So if that is so, no need for any appellate jurisdiction. You can directly come to us.
Indeed, Your Lordship.
But then the other point which we are talking about, tribunal not constituted, may not be a very valid point here.
Your Lordship, that point is raised in argument. If we were to go before the first appellate authority and their order would have hindered any of our rights, then the only other remedy we would have been before the tribunal, which
Not
is,
necessarily. Even thereafter, you could have approached us.
however, Your
After
Lordship,
the first appellate authority, saying that we don't have the second appellate authority, it is not constituted. The remedy is here. That is why we are knocking at your doors.
in
All right, we will not argue with you. We will proceed.
much obliged, Your Lordships. Your Lordship, this petitioner would like to move on to his second
Another-
issue.
Another 2 minutes,
The petitioner seeks.
whatever time is available, you can just
Your Lordship,
your aspect of the arguments, you can sum it up within 3 minutes.
Your Lordship, the council seeks an extension of 5
You
minutes.
want 5 minutes, all right.
Much obliged, Your Lordships. Your Lordships, if you have no questions regarding the first issue, the council would like to proceed with the second issue.
Yes,
Much obliged, Your Lordship. It is humbly submitted that this GST department has the jurisdiction to issue the show cause notices in circumstances where it has reason to believe that there has been a non-payment of taxes under Section 73 of the Act and willful evasion of tax liability under Section 74 of the Act. However, the department has furnished the petitioner with all the relevant reasons and evidences to prove the petitioner's evasion of duties. However, the respondent cannot allege any such grounds in the present case. and the impugned show cause notice are hence without jurisdiction as the alleged service provided to the petitioner is not liable to GST per se. Furthermore, the SCN is time barred in itself. It is humbly submitted that being a creature of the statute, the respondents have only been given the power to exercise jurisdiction over transactions which are taxable as per the Act. Hence, when the services are not per se liable to GST, the department has no jurisdiction to initiate proceedings against the petitioner by issuing show cause notices. Furthermore, as stated earlier, there is no supply in the present case, and since the services provided in a contract or service are specifically excluded from the purview of GST, there is no question of tax liability. Your Lordships, it is stated that neither of the SCNs could be issued in the first place. The respondents have issued the first SCN for the period of 2017 to 2022 under Section 74 of the Act. However, invoking Section 74 of the Act, there must be a willful misstatement, suppression of facts, fraud, or collusion. And none of these elements can be proved by the respondent in the present case. If the respondents allege that there is a presence of these elements, then the investigation must indicate that there is material evidence. Your Lordships, if you may refer to paragraph 19 of the memorial provided. The only alleged ground by the respondents that the petitioners failed to discharge the alleged tax liability of the GST regime, despite accepting the order of the Honorable High Court for the service tax regime. On the basis of this, the respondents have assumed that
Mr. Counsel, you summarize the arguments. Please don't read your memorial.
Indeed, Your Lordship. Your Lordship, if I have to quickly summarize the second argument,
Yes.
it would be that they have no grounds under Section 74 to issue a show cause notice because there has been no collusion, willful misstatement, fraud, or misrepresentations of fact. Even the respondents were aware of the arrangement and yet chose not to issue a show cause notice for 7 years since the inception of the GST statute. Furthermore, in arguendo, they could have raised a show cause notice under Section 73. However, raising of a show cause notice under Section 73 for the year of 2017 and 18 is time barred in 2024. And therefore, they could not have raised such a show cause notice. Your Lordships, if you're satisfied with the submissions, the Council would seek an extension of 1 minute.
Brother is asking.
By all means, Your Lordship.
It appears to be the department's case that in the previous regime, service tax regime, you accepted
Indeed,
this
Your
court's
Lordship.
order.
Indeed,
And there was no change in the transaction post introduction of GST also.
Indeed, Your Lordship.
So in spite of that, if you choose not to pay, that is a clear intention to evade tax, right? So which gives them a right to issue show cause notice under 74.
Your Lordship, the Council humbly disagrees. The choice of payment of service tax under the service tax regime in 2017 was mere commercial prudence on the part of the petitioner. The petitioner was not such a big company to actually assess further charges on litigation.
So you choose whether or not to pay tax and you expect the department to accept to it. So
Yeah.
when there is no change in circumstance, why would you not even check or, reach out to the department with regard to payment of the tax? And you yourself have decided that you believe that it is not liable to GST, therefore I will not pay.
Indeed, Your Lordship, because the petitioner has a bona fide belief that there is no tax liability on an employer-employee relationship. And therefore,
Okay, now one fundamental question, which is the taxable element here? Is it the services rendered by the employees to the Indian company, or is it the supply of those employees by the foreign company to the Indian company?
it is the supply, Your Lordship. It is essentially
Supply of what?
supply of manpower services as the respondents
From whom?
allege.
From
From the US company.
Is there any employer and employee relationship between the US company and the Indian company?
Indeed, Your Lordship.
Between the Indian company and the US company, who's the employer here?
Your Lordship, essentially, in the present case, the employer is the Indian company.
Correct.
The
Now, if we have understood correctly, the taxable element here is the arrangement of employees by the US company to the Indian company.
Indeed, Your Lordship.
And the second leg of the transaction is the employees rendering services to the Indian company.
Indeed, Your
What is exempt is only the second leg.
Indeed, Your
But the
Lordship.
first part, arranging or renting out or whatever you call of the employees by the US company to the Indian company is not exempt. And that is what the department is trying to tax.
Your Lordship, however, the US company is not in the service of arranging or rather than picking out employees for the Indian company. It is essentially only referring employees to the Indian company and nothing more.
Fine, go ahead. I mean, now that your time is winding up, you can conclude.
Your Lordship, if the Council can have an extension of a minute to summarize this third issue. Your
Yeah,
Lordship.
here regarding the question
Indeed, Your
you're
Lordship.
answering. Whether the Indian company has the right to terminate the employees appointed or the US company? Who
Uh,
has got the right to terminate the employee?
Indeed, Your Lordship. Your Lordship, before I give my answer, I would like to state that my co-counsel will deal with the issue at length. However, to summarize it, I would say that the Indian company can terminate the secondment agreement with the employees. Though for the period of 2012 to 2022, the power to terminate the employees is with the US company. And the Indian company can terminate the secondment.
You was establishing there is employee-employer relation.
Indeed, Your Lordship.
Okay. Now you are telling that only US company has got the right to terminate.
Indeed, Your Lordship.
So it's the US company, the employer, right?
The council humbly disagrees. There's an argument of dual employment here as well, Your Lordship, which my co-counsel will deal with.
Dual employment, can you prove that they have received double salary?
Your Lordship, the facts are silent on the matter. The facts of the case are silent on the matter.
No, it is
Alright.
clear. Only one salary was paid. There's no condition. There was a reimbursement arrangement. That's all.
Indeed, Your Lordship.
Only one salary to these employees.
Indeed, Your Lordship.
That's how RCMS come into picture.
Indeed,
We,
Your Lordship.
we will ask these questions to your co-counsel.
Co-counsel.
Now that you have passed it on to her, you sum
Your
up.
Lordship.
You have only 1 minute left.
Indeed, Your Lordships. The third issue at hand, Your Lordships, is whether secondment arrangements are liable to GST. In general, a secondment arrangement, there's no straitjacket formula which can assess the liability over secondment arrangements. However, referring to the case of MS Fiat, the substance over form principle is put in place that one should see the substance and form of the secondment agreement, and not essentially put any other case, put the precedence of any other case in the factual matrix of another case. It is summarized that the secondment agreement in the present case is not liable because it is a contract of service and not for service. There's an employer-employee relationship between the seconded employees and the petitioner. Furthermore, the employees have not helped in the furtherance of the US's company's business and have only been doing the bidding of the Indian company for the past 24 years. Furthermore, differing from the judgment of Northern Operating Systems versus C-Start Bangalore, the Indian company is not providing any back office support to the foreign entity. It is an entity of its own which is working to further its own business.
All right.
Much obliged, Your Lordship. If the Lordship are satisfied with the submissions, I ask my co-counsel to take the dais.
Yes. All right.
Much obliged, Your Lordships.
Counsel, your name?
Akriti, Your Lordship.
Hmm?
Akriti.
All right. Proceed.
Issue number 4, Your Lordship. Whether based on the experience letters issued for the period from 2010 to 2022, it can be said that there will be no GST implication for this period. For this, Your Lordships, it is submitted that petitioner has the power to issue these experience letters for the period of 2010 to 2022 to the seconded workers, as firstly, they were deemed employees of the petitioner for this period. And secondly, as they were the deemed employees, no GST liability arises by virtue of Schedule 3, Your Lordships. The first part of the argument, it is submitted that the secondment agreement constitutes an independent contract of service in respect of employment with petitioner rather than creating a contract for service as alleged by the respondents. To determine whether the contract is of service or for service, there is not a single a priori test which determines this aspect. As held in the case of Sushilaben Indravadan Gandhi versus New India Assurance Company Limited, a conglomerate of various tests has to be seen to determine the true nature of a contract, whether it is a contract of service or contract for service. The most important of all is, Lordships, the control test. As the law laid down in Shivanandan Sharma versus Punjab National Bank Limited, if Your Lordships may refer to page 66 of the compendium provided.
Read the relevant portion only.
Indeed, Your Lordship. The test is the existence of a right of control over the agent in respect of the manner in which his work is to be done. A servant is an agent who works under the supervision and direction of his employer.
No, we will, initially, we would like to ask you this question, which we posed to your colleague. See, you enter into an agreement, virtually antedate the relationship. You treat them as your permanent employees right from 2012, isn't it? 2012,
10.
2010.
Your lordships, yes.
And what is the purpose behind this? How can you do this? How can you have yourself agreed in the previous round of litigation? You have paid the tax. You said that, yes, the control is elsewhere. They are deputed from there. And we agreed to pay the tax. Now for the said period also, you include them in your permanent employees list and say, they are our employees right from 2010. What is the, how does your, how do you come, get over your intentions, purposes, and we doubt this conduct on your part. What do you say?
Your lordships, first of all, it is this case of the petitioners that the secondment agreement, which was entered into between the parties, this should be treated as a contract of service, which is creating the relationship of employer and employee between the seconded workers and the company, your lordships. And this agreement, the petitioner company, your lordship.
Indian company or foreign?
The petitioner Indian company and the seconded workers. This the secondment agreement is a contract of service, and that is creating a relationship of employer and employee between the seconded workers and the petitioner company.
Is there any other agreement which you have with your offshore country, that is a United States company,
As per the facts, your lordship,
authorizing you to treat them as your employees forever time to come? No need to send them back. We want to know if you want to throw light on your conduct and say it is a bona fide transaction, bona fide agreement, then there should be a parallel agreement with them saying that we don't need these staff. We have, you do whatever you want. We want to terminate them. There should be termination on their part, and then they are available for employment by you. Isn't it? Is there any such agreement?
no, your lordship, as for the facts, there is no such agreement. But it is contended that since 2010, the secondment agreement, which should be treated as contract of service, providing various tests that for better navigation, the council requests the bench to refer to page 9 of the memorial provided. Given all these tests, the council will conclude that this secondment agreement was in a sense creating a was in a sense a contract of service, and it created a relationship of employer and employee. And issuance of these experience letters, this can be done. Experience letters are what, your lordships? It is given when you have to certify that from this to this period, this worker worked under our organization, and he has the experience of working under our organization. Now, your lordships, pertaining to the fact of retrospectively giving its effect.
You need to address our suspicion.
Yes.
Yes, Lord, I'm coming.
We are legitimately on the basis of certain facts here, entertaining a suspicion that you are trying to defeat the law by entering into this kind of agreement with these so-called seconded employees, who are the permanent employees of an offshore country, offshore enterprise, isn't it? So address that suspicion if you want to.
Your lordships, as per the fact, there is nothing barring in the secondment agreement to treat these workers in dual employment with the petitioner company. If your lordships may refer to page 10 of the memorial, your lordship.
Here is a question for you. You issued a letter, okay? That letter can be predated. That was the suspicion. Whereas it's a private limited company registered with Registrar of Companies, Bangalore, right? You'll be filing the annual returns and you will be accounting the salary. You'll be subjecting the employees for TDS. under 192 or section 195 or 194J or 194C. That should be the evidence to prove your case, not just the letter, a predated letter. Can you change the annual returns already filed with ROC?
Your lordships, all
Is
these.
it a reimbursement or is it a salary? How you have accounted?
Your lordship, the salary was provided by SOSUS, but however, all those expenses were reimbursed by the petitioner company, and that will be reflected in the annual returns as well.
Counsel, we would only like to know that if your whole objective was only to avoid GST, because it is not a prospective arrangement, you seem to have issued a letter which is capturing the past 7-8 years. So if the only objective was to come out of GST, especially when you want to cover the period when the show cause notice is issued, if it is an afterthought, only to avoid GST, then I think we will be giving more importance weightage to the substance rather than the form. Your mere letters cannot come for your rescue. We would still treat as they are the employees, legal employees of the US company, and they were seconded to you. And therefore, there is manpower supply, and therefore you'll have to pay GST also, as you paid service tax.
Your lordship, the council humbly disagrees, as the petitioner company was under the bona fide belief that these workers, seconded workers, are in a sense, are substantially the employees of the Indian company. And looking at the substance over form doctrine itself, by if your lordships may allow the council to refer to various tests, the council will prove that applying these tests, the substance of the secondment agreement was that of creating a relationship of employer and employee. And that's why no GST liability arises, your lordship.
And why wouldn't you, at the time of entering to the agreement itself, say that because if you seem to have all control over the employees, you need not have entered into a secondment agreement at all. You could have very well, as lordship said, you could have terminated them from the US company and you could have freshly recruited here. So it appears that now that you have been caught in the cobweb of GST, you want to do something so that you have this evidence being created saying that, see, these are all my employees. Therefore, I would take the exception. That's what our prima facie view is.
Your lordships, as tax planning for companies is allowed, as long as it is within the ambit of law. And if the councils can prove that whatever tax planning was done by the company was within the ambit of law, no liability of GST and no jurisdiction of the GST department arises, your lordship.
And the issue is not only with the paying of the GST, you are giving a letter effective from 2010. How is it possible? What is the legal validity? On what grounds? And even you have collected the salary, you've also been paying the statutory PF and it. What all happened to that? As my brother was saying that, see, annual returns you have filed. So how are you going to substitute, which is a very clear case, which is highlighting that it is only with an intention to defraud the GST you have done the letter, you have issued the letter.
Your lordship, the council would like to bring notice of various labor law cases where the court essentially give effect to employment retrospectively to give them benefits.
So you are saying it's a retrospective?
These experience letters, your lordship?
Yeah.
Indeed, your lordship, they are having an effect from 2010 itself, because from 2010 itself, the relationship of employer and employee existed. And that's why this experience letter is issued. Your lady.
See, all this are raised up only after the RCM has been charged, asked to. So this is, which is a clear case of, which is evidencing that it's an afterthought and it is only intention is to not to pay the GST.
The council humbly disagrees, your lordship.
It is our prima facie opinion.
Yeah.
And your disagreement will not do anything with us.
Your lordship,
and I may tell you that when you address the court, you need not have to say you do not agree. How does it matter whether you agree or not?
your lordship, if the council may come to the point.
No, on the lighter side, I am telling you that when you address the court, no need to say whether you agree with us, do not agree with us, it makes no difference. The only thing that matters is we agreeing with you.
Yes, indeed, your lordship. Your lordship, the challenge for the demand for RCM was made in 2024 by the department. However, this arrangement was entered between the parties in 2022. So it is not that after the demand has been made, this agreement has been entered.
Yes, please proceed.
Much obliged, your lordship. So for control, your lordship, there are two tests. First, it is the employer that should be in control of what work will be assigned. and in what manner that work will be done. So in the present case, it is the petitioner company that is in complete control of what work will be assigned to these workers and in what manner this work will be done. Further, in the case of Silver Jubilee, Your Lordship, if the bench may refer to page 69 of the compendium provided.
Yes.
Your Lordship, this case pertained to the tailor shop workers. So from there, the council will draw the parallels. The fact that generally the workers attend the shop which belongs to the employer and work there on the machines also belonging to him is a relevant factor. When the services are performed generally in the employer's premises, this is some indication that the contract is a contract of service. Now, Your Lordship, in the present case, these seconded workers are working in the premise of the petitioner company. They are situated in India for the past 14 years. They are working only for the benefit of the Indian company, using the resources of the Indian company. And that's why this is indicative of the fact that this contract is a contract of service, Your Lordships.
It's also working for the US company because the intention of sending 24 employees to India was to establish or capture not only the Indian market, South Pacific, and also to add value to the services, after sales services, global. That was the global perspective. So even US company will get benefited. It's not just for the Indian company, they have been posted. It's win-win situation both ways.
Your Lordships, however, both these companies are distinct persons in themselves. So they are essentially working for the benefit. They are completely devoted to the working of Indian company from the period of 2010 to 2022. And they are not doing a single work of the US company. Their complete devotion is towards the Indian company itself, Your Lordship. So that's why it is the case of the petitioners that this contract is a contract of...
Research and development is also part of the employment. That was it. It's an intellectual property what they are dealing. It's not that example you quoted, that Tyler. It's not like that.
Pardon, Your Lordship?
See, this is a software development company. So developing a software, developing a patch, they have a global approach. It can be mutually used by everybody throughout the world.
Indeed, Your Lordship. However, the council found this argument in the research, but since it was not seemed relevant, it is not included in the compendium. But however, the council would argue that under the IP taxation, the transfer of technical know-how between the companies is not taxable, Your Lordship. The technical know-how...
There are too many issues you're trying to bring around. Okay. Stick to what has been asked you, right? No. Just look at page 9 of your this memorial, or whatever you call it. Memorial. There are about 4 tests you have indicated there, right?
Indeed, Your Lordship.
Economic reality, nomenclature test, master servant, control test, integration test. Now, are you trying to say that if you apply all these 4 tests, the persons who have been recommended or seconded here will ultimately become the employees of the Indian company, number 1. Number 2, they are paid salaries as employees by the Indian company to them. They go by other statutory provisions where they are treated as employees by the Indian law. Therefore, you apply the test of substance, look at the substance of how they are, they will be treated as employees. Do all this, ignore the agreement which the Indian company has with the foreign company. Is that what you're trying to canvass?
No, Your Lordship. What the council is trying to say, that the agreement that the Indian company has with the foreign company, this should be treated as a contract of service. And for proving that this is a contract of service, these tests have been relied, because they are showing how a contract, what is the difference, how to determine whether a contract is for service or is a contract of service, Your Lordships. And that's why these tests have been relied.
Counsel, one basic question, how would it really matter whether it is contract of service or for service? When what is being seen is whether the secondment of employees is the taxable event. It does not really matter how the Indian company treats its employees, whether as a consultant or whether as an employee. But what we are looking at it is how the sending of those employees from the US company to the Indian company. If there is said to be a supply, if there is safety of what an erstwhile regime called as manpower supply, then it is liable to GST. Because there is no requirement that there has to be consideration for the imposition of GST. So it does not really matter whether he is really an employee of yours or not. But whether there was any rendering of service by the US company to the Indian company by sending the expert, which otherwise you will not be able to obtain. But for a relationship between your company and the US company, you would not have got this expert in the first shot. Isn't it? So is there no service element between the US company and the Indian company? There seems to be one. That is the taxable event here, not the relationship between you and your employees, seconded. I think that's what the department's case itself is.
How do you respond
Indeed.
to that? How do you respond to that question? Please answer that question.
Indeed, Your Lordship. Now, just merely supplying manpower will not be a taxable event. That's manpower which has been supplied should work for the recipient of that service. And it is the case of the petitioner that the work that this seconded worker was doing, he was doing in the capacity of employee of the petitioner company. And this contract, whether it is a contract of service or contract for service, becomes of utmost relevance, because if it is a contract of service, the GST liability will be exempted by virtue of Schedule 3, Your Lordships. But if it is contract for service, the GST liability will arise, Your Lordships.
No, but which is the activity they want to tax? Do they want to tax what the foreign company provides to the Indian entity? Or do they want to tax the activity which the employee provides to the Indian entity? What is the activity they want to tax? They want to tax the first activity or the second activity?
Your Lordship, they want to tax the activity of supplying that manpower.
Yeah.
But in order to treat them as manpower of the Indian company, they have to work for the Indian company first. Right, just merely that they sent, and if they don't work for the Indian company, they are not supplying the manpower. They just send some people to India. So
Right, that is the point you are making. We want you to highlight that. For that, we asked you initially this question. See, you have entered into a fresh agreement. Their services are terminated and you have taken them. Virtually, they are your employees. You are saying you have absorbed them. There is no relationship of employer and employee relationship or any other relationship with a foreign company. They are your employees right now, isn't it?
indeed, Your Lordship.
Ah.
But
So you are proceeding on that premises. All right, we posed you some questions which arise under the, don't get disheartened about it and proceed
Certainly not,
further. Proceed further.
for Your Lordship, as per the agreement, originally it is the liability of the petitioner to disburse the salary of the secondants. The council would like to bring notice to the paragraph 2 of the Moot proposition.
Yes.
The last line, Your Lordships. If and when they were sent to any offshore group company, for example, like SOS India, it was decided such host company like SOS India should incur the salary and other expenses of these personnel who are seconded to such host companies. So, Your Lordships, may the council request for an extension of 5 minutes.
All right. Finish it within 5 minutes. We will not further extend it. So once he
Certainly.
shows you the time, then close it. We will not interrupt you.
Certainly, Your Lordship. So originally it is the liability of petitioner company as per the agreement to disburse the salary. But only for the sake of convenience, it is the US company who is disbursing the salary, and all of these salary expenses are being reimbursed to the US company itself, Your Lordship.
But I draw your attention to serial number 10 of the fact sheet. There, it's mentioned that labor benefits like gratuity, insurance, provident fund, etc., is to be passed on. Okay, they will be under what law? It is Indian labor laws, right? Indian labor laws. And if you issue a letter with retrospective effect, what would be the accounting? if statutory liabilities are not cleared within the due date, it will be disallowed and taxed, is it not? Have you taken care of that aspect before issuing that letter? And in that serial number 10, it is clearly mentioned that was the intention
Indeed, Your Lordship.
of this arrangement, new arrangement.
Your Lordship, first of all, if, the concepts of gratuity and all this comes under the, when it comes to paying the income tax, Your Lordships. So this will be dealt by the income tax department, and this case pertains to whether the GST is leviable on these services or not.
As and when that problem comes, you will answer it.
Indeed, Your
And when
Lordship.
the
Yes,
labor department asks you to answer, you will answer. That is your answer.
Your Lordship, certainly, Your
Now,
Lordship.
my brother's question was, before you ventured upon this kind of an enterprise, did you think about the welfare legislations like the other PF and other provisions, which you have to remit periodically? If you say, for the last 10 years, they are my employees, they are my permanent employees, then you will be landing in trouble. That is what the question is, and perhaps your answer is, as and when the situation arises, you will answer that question. Now we will confine to GST.
Because
That is precisely why we are saying that this is a camouflaged agreement. You are trying to defeat the provisions of law, which cannot be permitted. That is the first question, and a very substantial question which you have to answer. If you want to devote some more time on that, you can definitely do it.
Your Lordship, because of the constraint of time, may the council
right,
proceed to
all right.
further issues.
All right, all right.
Certainly, Your Lordship. Also looking at the economic reality of the transaction, Your Lordships, it is looked into for whose benefit the workers are working. And in the present case, it is the petitioner company for whose work, for whose benefit the
That's your contention.
Lordship, that is provided in the facts itself.
No, in the fact sheet, you read the paragraph 1, it is very clearly mentioned the intention of forming the subsidiary company was to service the global requirement.
Your Lordships, if I may bring your attention to para. Para 9, Your Lordships.
No, 9 deals with that is June 2022 onwards and prior to June 2022. That is para number 9, right?
Your Lordship, it is
All right,
written. It is written that for all economic purposes,
in para 9, where you want to invite our attention?
for all legal and other purposes, will be treated as employees of. Sorry. Pardon, Your Lordships. It is stated in the facts that for all economic purposes, it is the petitioner company who will be in charge of these employees.
No,
And for all economic purposes will include that they are working for the benefit of the Indian company, Your Lordship.
no, this decision was made subsequent to the Karnataka High Court decision and followed by the Supreme Court decision. You thought it fit to buy peace and to avoid litigation, you have made an arrangement of terminating the employees from the US company, admitting the same employees under the same terms and conditions with the Indian company. That is from June 2022 onwards. Okay, that's what para number 9 says.
Your Lordship, that was done to properly, for proper tax planning of the company. It was noticed by the company that this unclear arrangement, that whether they are certainly employees of the company or not, this was creating unnecessary tax liabilities. And so because of that reasons, the 2017 judgment was passed, Your Lordship.
You call it tax planning, the department calls it tax evasion, that's all. By calling a donkey a horse, it will not become a horse.
Your Lordship, because since they've it is proved by relying on various tests. It
We
can
will not
be
tax
said-
you with more questions. You sum it up. I think your time is getting over. You sum it up.
Indeed, Your Lordship. So for issue 5,
Yes. 2 minutes, sum it up.
indeed, Your Lordship. Whether based on the arrangement from 1 June 2022, it can be said that there will be no GST implication. Your Lordship, post 2022, the service that the department is alleging is that of manpower recruitment service in nature of identifying and arranging these employees. Your Lordship, in the umbrella of manpower recruitment or supply services, there are two services that come into picture. Prior to 2005, there were two services, distinct services, manpower recruitment service and manpower supply service. Post 2005, these were included together. Now, what post 2022 they are alleging is that manpower recruitment service, that this SOS US is helping in recruiting these employees to the petitioner company. It is submitted, Your Lordship, that no such agreement has been entered into between the parties for supply of any such alleged service. And in absence of such an agreement, this cannot be said that there was any such supply of service, Your Lordship. And since they are employees, no tax liability arises.
Okay.
Coming to sixth issue, Your Lordship, whether there is any import of service and any tax liability under reverse charge mechanism arises, it is submitted that for import of service, 3 ingredients needs to be fulfilled. First, the supplier should be located outside India, the recipient should be within India, and the place of supply should be India. Now, since there is no supply because the service is exempted by Schedule 3, it is submitted that there is no import of service since there is no supply. And if there is no import of service, the liability of petitioner under reverse charge mechanism does not arise, Your Lordship.
Should this not be your first argument?
Pardon, Your Lordship?
Should this not be your first argument?
However, Your Lordship, this was dealt with in issue 6.
We would have
The Counsel-
forgotten it if you had said it as a first argument. That is why you are emphasizing it as a last argument. Good. Yes. Sum it up, sum it up.
Indeed, Your
Anything more?
So to conclude, Your Lordship,
To tell you frankly, we are noting your arguments. We'll never forget.
much obliged, Your
Time is
Lordship.
over.
May the council proceed to the prayer if Your Lordship
Yes,
grant
yes, yes.
1 more minute.
Yes, proceed to the prayer and finish it off.
Certainly, Your Lordship. Wherefore, in the light of facts stated, issues raised, arguments advanced, and authorities cited, the counsels on behalf of the petitioner humbly pray before this honorable court that it may be pleased to adjudge and declare that 1. The writ petitions filed by the petitioner are maintainable before this honorable court, and 2. The respondent did not have jurisdiction to issue the impugned SCNs, and 3. By means of writ of mandamus or any other appropriate writ, order or direct the quashing of the two show cause notices issued by the respondent, and 4. Stay further proceedings against the petitioner pursuant to the impugned show cause notices issued by the respondent.
How do you quash it by issuing a writ of mandamus? What is the writ issued for quashing a particular order?
Your Lordship, quashing an order of a judicial authority is certiorari, but if it comes to quashing an order of a quasi-judicial authority, this comes under the writ of mandamus, Your Lordship.
The mandamus is a direction. You issue a writ, if it doesn't fall under certiorari, we have discretionary writs to be issued. Any appropriate writ, this,
As it deems
you are
fit by the
asking for
honorable court.
mandamus. Why do you ask for mandamus? Mandamus is a direction.
Your Lordship, if the court deems fit that a writ of certiorari should be issued, it is in the prayer that any other appropriate writ, Your
All
Lordship,
right, all right.
and pass any order that the honorable court may deem fit in the light of justice, equity, and good conscience. And for this act of kindness of Your Lordships, the petitioner shall duty bound ever pray.
Including prosecuting you for not disclosing true facts before the court. Come. That is on the lighter way. Come.
Much obliged, Your Lordship.
You means your client, not you. When we say you, it is nothing to do with the lawyer.
Certainly, Your Lordship.
Yes, please proceed.
The council seeks permission to address the bench collectively as Your Lordship.
Your name?
My name is Vedant, my lordship.
All right.
May it please this honorable court. This is Vedant on behalf of the respondent, Additional Commissioner of GST and others. Your lordship, the petitioner respectfully requests the time breakup as such, 21 minutes for that I'll take for addressing issue number 1, 2, 3, and 7 of the memorial, and issue number 4, 5, 6 by my co-counsel. And she'll also be taking 21 minutes of honorable court's time, and will reserve 3 minutes for rebuttal.
You leave that to us.
Obliged, my lordship. Your lordship, the respondent has approached this honorable court responding to the writ filed under Article 226, challenging Section 74(1) of the CGST Act 2017. Counsel would like to tender a brief list of dates and events across the bar for the easy reference of this honorable court.
In this particular case,
Yes, my lordship.
you're telling SOS India Private Limited Bangalore versus Additional Commissioner of GST and others.
Yes,
Who are others?
my lordship, Union of India is certainly one of the parties to it, but rest, the fact is silent upon the same. May I proceed, my lordship?
Yes, yes.
Do my lordship require a brief summary of the fact?
Not necessary. We are now aware of the facts.
Obliged, my lordship.
You
Lordship,
are sufficiently harassing all the people, including companies abroad and inside our country.
yes, obliged, my lordship. Lordship, the first issue shall be dealt with by the on the concept of maintainability. The council submits that this writ petition is not maintainable, and the same shall be substantiated in a threefold argument. Number one, the scope of writ is narrow. Lordship, this further shall be substantiated in two limbs. Point number one, that this particular writ petition does not fit in the criteria of Article 226 itself. Lordship, there has been no infringement upon the fundamental right of the petitioners, as the petitioner submitted that they claim that their Article 19(1)(g) has been infringed. Lordship, there is a precedent of the Honorable Supreme Court I have with me by the name of Kishore versus State of UP, wherein it has been mentioned that, and it has been observed by the Honorable Court that the writ that this particular Article 19(1)(g), the article does not apply to the person, it applies only to the citizens. And as per the law, a company, which here in this case is SOS India, is a person and not a citizen of this particular country, primarily. Secondly, there has been no violation of natural justice, my lordship. I request my lordship's attention to paragraph 12 and 13 of the Moot proposition.
Yeah, you state the substance of it.
Yes, my lordship.
Read it.
So, my lordship, it is evident that post the issuing of the show cause notices, the petitioners were giving requisite time to respond to the same. And looking after everything and looking into all the aspects, only then the demand was confirmed. Therefore, the idea of violation of natural justice doesn't arise at the very outset here. Now, talking about the next point of contention, my lordship, there is an
No, you started with jurisdiction.
yes,
Said they have no jurisdiction to approach this court.
yes, my lordship.
See, if their case, as they pointed out, the last of their point, which my brother pointed out, why you did not take up that contention as first. If that is accepted, if the act itself has no application, why should he subject himself before the authorities? He can straight away come here, act has no application. There is no jurisdiction. They can't issue show cause notice, let alone passing any order, remand.
Lordship, for this, I would like to invite Honorable Court's attention to paragraph 9 and paragraph 13 of the Moot proposition.
Yes.
Here it's precisely mentioned that the terms of new employment were such that the expats, for all legal and other purposes, will be treated as employees of the Indian company, not just from the date of issue of the new appointment letter by the Indian company in June 22, but from the date of these expats were seconded. Lordship, the important date to be noted here is June 2022.
Yes.
Now I request my lordship to turn to page to paragraph 13.
Yes.
Lordship, here it's written, the Indian company countered the SCNs on the lines that the period from 1st of July 2017 to 31st May 2022, the employees were terminated from the services.
Yes.
So basically, my lordship, I'm trying to point out here that they have presented a different bracket of time altogether, which in their reply to the show cause notice. And as a matter of fact, the time that has been mentioned is different. And moreover, it is out of the ambit of this particular time itself. So this states a willful misstatement from the side of the petitioners, and therefore this gives the authority to the respondent to act in a particular manner in directing in issuing the show cause notice under section 74(1) of the pertinent legislation, my lordship.
Here, you have issued two show cause notices.
Yes, my lordship.
One prior to 31st May 2022, one subsequent to 31st May 2022.
Yes, my lordship.
As far as from 1st June 2022 onwards, okay, if one can establish employee-employer relation, GST is not liable. Will you agree with that?
If the petitioner or anyone approaches to this honorable court with clean hands, will surely agree and will concede to this honorable court's jurisdiction. But my lordship, here in this particular matter, they have the chronology of the
No,
event.
only I am asking you this question only for the second show cause notice, not the first one. First, we will decide later. As far as second SCN is concerned, it is subsequent to 1st June 2022, subsequent to the amendment or implementation of GST, and it is clearly defined wherever employee-employer relation is established. GST is not liable. It is there in the Act. Can you prevent an assessor or a dealer to utilize the legal
Remedy available.
remedy available? Let them do tax planning or whatever it is. When the law has given, the intention of the legislature is let the dealer be benefited. How can you prevent?
Lordship, if the dealer is benefited with a noble notion, that is for sure not an issue. But here in this particular matter, the second show cause notice cannot be abstractly seen, and both needs to be conjointly seen. That is the point I am trying to make here. And my lordship, the two different show cause notices, the very idea behind the same was that to put a clarity that before our arrangement was different, which was a secondment arrangement, and the second, in view of the Supreme Court judgment of 2022, they planned an innovative arrangement, which again is flawed if we look into the chronology of the events.
No, if the employees have left this company, for example, an employee of Infosys leaves and joins Wipro, in such a case, do you have any argument?
No, my lordship.
So
my
here
lordship.
also, he has left one company and joined the Indian company. In what way it's different?
Lordship, if we talk about the example that my lordship gave, they are two very different entities. Here, the intent, the sole idea of issuing the show cause notices under section 74 is the challenge, is that we are challenging the intent of the petitioners. And when we talk about intent of the petitioners, my lordship, again, I reiterate that. Yes, my lordship.
The US company and Indian company, they are two different
Yes, my
entities
lordship.
altogether. You agreed for that?
Yes, my lordship, I certainly agree to this. But my lordship, the point is that they have acted conjointly in a manner to evade taxes. And my lordship, as far as the idea of planning is concerned, planning is done for future references and futuristic events. It's not done for retrospective acts.
That's why my question was only for the second show cause notice effective from 1st June 2022.
In arguendo, my lordship, I shall agree.
All right, you proceed further.
Sure.
You have answered the way you wanted. You proceed further. We have made a note of it.
Yes, my lordship. So, my lordship, the second limb that I would like to present was about the availability of alternate remedy. This honorable bench has already mentioned about the first instance of appeal that was available to the petitioners in the form of going to the commissioner. My lordship, I would have agreed, and the respondents would have certainly agreed had the writ would also have been infringed, other than the different rights, if so is the case as contended by them. But my lordship, since only legal right has been an issue and has been a problem, since I have established that there was no breach of fundamental right, infringement of fundamental right here, therefore they only had the remedy of approaching the first or the commissioner first, and then they would have approached this honorable court.
Is
No.
it your case,
No, no,
counsel,
yeah,
that to
Tribunal.
approach the High Court under Article 226, only the fundamental rights should be breached?
No, my lordship. No, my lordship, not at all.
Then
In
why would
fact-
you say it is only the legal right that has been violated?
Yes, my lordship. Here in this matter, only the legal right of the petitioners has been violated.
Correct.
It is upon the discretion of this honorable court. This has always been a discretion of the rule of law and the rule of notion, the notion of discretion, my lordship. It is upon this honorable court's discretion to admit this and entertain this writ petition, my lordship. The court has the full duty, but the point is it is a matter of policy that and self-imposed policy upon the court.
No, if the alternative remedy is available
Yes, my lordship.
and alternative remedy is efficacious, still you say this court has discretion to say, even though you have alternative remedy, I will entertain you? Why are you leaving that discretion to us? Tell the proposition of law.
No, correct.
Tell the
Mhm.
proposition of law. If there is a statutory remedy, an effective, efficacious remedy, the writ court shall not interfere.
Lordship.
Is it your contention, or you may interfere if you choose?
No, my lordship, the
You don't-
i- the
you don't-
idea of
Yeah.
the idea of creating a statute is for easy redressal, and if an alternate remedy is available as a matter of law and not as a matter of discretion, then the matter of law should be given preference over matter of any other thing.
We want you to assist the court in that way.
Correct.
Yes, my lordship.
Don't put the discretion and say, and tomorrow go to the next court and say, they had no discretion. Whatever
Certainly,
you
my
want to argue here.
Yes, certainly, my lordship. My lordship, I would like to now move on to the second issue, subsistence that
Look at your list of dates, look at your list of dates.
yes, my lordship. Yes, my lordship.
Serial number 6,
Yes, my lordship.
2017.
Yes, my lordship. Yes, my lordship.
The Karnataka High Court ruled that SOS India must pay service tax under RCM for importing services. As seconded employees were considered as manpower supply services.
Yes, my lordship.
So in 2017, there is a High Court ruling against them.
Yes, my lordship.
But you fail on extended period. That's what that says.
Yes,
The
yes, my
court
lordship.
Dismissed the show cause notice related to extended limitation.
Yes, my lordship.
Now, the Supreme Court comes in 2022,
Yes, my
the
lordship.
next page.
Yes, my lordship.
Thereafter, you issue notice in 2024.
Yes, my lordship.
Now, what is the alternative remedy you expect the assessee to have? There is a High Court ruling saying that it is a secondment of employee. On merits, it's decided against them. What will you decide, saying that is your respondent will decide, saying that there will be no secondment or there will be no tax. Once the High Court has decided it in 2017, what can you do in the notice of 2024? Therefore, are they not right in coming to the High Court now in saying that relook at the issue, right? Because there is no alternative remedy available to me.
Lordship,
Whether
one.
it is fundamental right or legal right, etc., slightly different. But the High Court having decided in 2017 that they are liable to pay tax. Why should they go through this alternative remedy to suffer the same consequence when the High Court has already decided it? So they come directly to the High Court to say that on re-evaluation of their agreements, the facts are different.
Lordship, I acknowledge the question of the honorable bench. Lordship, there is one important element, and there is a big difference from 2017 judgment and the issuance of show cause notice today in the year 2024. Lordship, that particular judgment was based on the erstwhile service tax regime, and a different statute was applicable.
What they different? How is service tax different from GST as far as secondment is concerned?
Lordship, the statutes have been silent upon the idea of secondment in particular. So but a broad difference between a GST and a Finance Act can be such that GST is a destination based tax system basically, and wherein a tax is imposed at every step, whereas the Finance Act is a physical law that the government brings with to govern the fiscal policies of the.
Service
Both
tax
are
too
the
was a destination
Both
based
are the
tax.
same.
That was also a destination based tax. We see no difference between this previous regime and the current regime. So at least one nomenclature has changed insofar as the secondment issue is concerned. There is no distinct provision both under the previous regime and this regime dealing with this issue.
Yes, yes, my
So
lordship.
it's all the same. It's just an old wine in the new bottle.
To my opinion, my lordship, we have a precedent of 2022, which would now govern the secondment, and the time has changed from 17 to 2024 here today.
Therefore, look at it this way. The 2017 High Court is against the SSC.
Yes, yes, my lordship.
2022 Supreme Court rules against the SSC.
Yes, my lordship.
2024 you issue a show cause notice
Yes, my lordship.
and you issue a notice under 74.
Yes, my
What
lordship.
will the SSC do?
My lordship, there was a point that in 2017, they already obeyed only after they paid the tax only after the Honorable High Court passed the order, and it was their duty to. It was their duty to come if at all they had any confusion and any sort of factual matters confusion.
You
So
have also issued a notice on your own. You know that they are an SSC. 2017, the High Court is against them. You know that they are existing. 2018, you could have gone to them. 2019, you could have gone to them. What prevented you from going to them for till 2024? How do you justify your ignorance of their activity?
You could have issued the notice under 73 itself without the extended period had it been prompt. So it appears that you are also there is laxity on your part also.
no, my lordship, requisite time was being given to the petitioners for the same, and it was only after looking into the intent and requisite time that this particular thing happened.
What did you see in 2024 which they did not disclose earlier?
My lordship, as I assisted the honorable court before also.
We have no case on limitation. We have no case on limitation at all.
My lordship, but I beg to differ, but as per.
As my lords pointed out, you differ, you don't differ, doesn't make a difference to us.
My lordship, but here in this matter, there has been willful misstatement from their end, which.
What willful mistake?
My lordship, I assisted this honorable court. They have actually tried to turn the facts.
Now you see it. We were only trying to see para 9.
Uh,
Para 9 of your statement.
yes,
of
my
facts.
lordship.
What do they say? Last 6 lines.
Yes,
Terms of new employment were that the expats for all legal and other purposes will be treated as employees of the Indian company, not just from the date of issue of the new appointment letter by the Indian company in 2022. Correct? So from 2022, they get this. But from the date, these expats were seconded to India in 2010. Thereby making the expats employees of the Indian company throughout the 12-year period. This making them retrospective from 2010 doesn't really make a difference because the High Court has already ruled against them in 2017. So whether they had an intention to do it from 10 or 17 doesn't make any difference. There is already a decision against them in 2017. Their letter doesn't make a difference to the entire issue. So you look at it from 2017 onwards. So when you look at it from 2017, from 2022, they are employees.
Yes, my lordship. Yes.
So now the question is from 17 to 22.
Yes, my
Do
lordship.
you have a case that they are not an employee from 17 to 22?
Yes, my lordship, I do have a case.
What cases?
My lordship, the very idea.
If they are
Lord-
an employee today, they are an employee yesterday.
No, my lordship, they weren't an employee. If my lordship, if I can get extension of 5 minutes. So yesterday they were, for all legal matters, they were employees of US company, the parent company. And post 2022, they became the employees for all legal and economic matters, the employees of Indian entity. So there is a big difference between the two, my lordship.
That's why they were laying down the test, economic test, control test, etc. to decide whether they are employee of the Indian entity or not. That's what they were laying down.
Actually, this matter shall be dealt in detail with my co-counsel, my lordship.
All right, whatever you want to deal, you deal.
Okay, my lordship. if due to paucity of time, may I move to the second issue, my lordship?
Yes, sir.
So the second issue talks about whether the department had jurisdiction to issue SCNs. My lordship, as I submitted before as well, the department was well within its jurisdiction and power to issue SCNs.
How many show cause notices were issued, counsel?
2 show cause notices, my lordship.
How many years are involved in this?
3 plus 4, 7, my lord, sir.
How can you issue 2 show cause notice clubbing all these years?
My,
The first period, there are 5 years. How can you issue a single show cause notice for 5 financial years?
my lordship, as per the,
And you expect the SSCs to file annual return for every year. Can they club all the 5 years returns and file as one return? That's not permitted, right?
yes,
How can a show cause notice be issued for all 5 years together?
because my lordship, it is established as per the statute. I would request my
Are they empowered? Are they
Uh,
empowered to issue one show cause notice for multiple years?
my lordship, I would like to invite this honorable court's attention to section 73 subclause 2 and section 73 subclause 10 of this honorable court. Sorry, 74.
What does it say?
Can I have? Determination of tax not paid or shortly paid or erroneously. The second one is, my lordship, the second subclause is, the proper officer shall issue the notice under subsection 1 at least 6 months prior to the time limit specified in subsection 10 for the issuance of order. And the subclause 10 talks about the proper officer shall issue the order under subsection 9 within a period of 5 years from the due date for furnishing of annual return. My lordship, the point here is that the respondent acted well within their jurisdiction. A notice can be issued for 5 years. It's just
We are not on that. We are not saying that regarding the limitation issue. We are on the number of show cause notices issued. You should show 2 show cause notices.
Yes, my
The
lord.
first one specifically,
Yes, my lord.
that covers 5 years.
Yes, my
So
lordship.
the question is, can one show cause notice be issued covering all 5 years instead of issuing 5 show cause notices?
No, my lordship, the point was that the arrangement before 2022 June and the arrangement post 2022 June was different.
So you're clubbing all the years. So issue wise you're clubbing, not by financial year wise.
No, my lordship.
If that is the case, then your show cause notice itself has it becomes invalid. You have issued only one show cause notice for 5 financial years. You ought to have issued separate show cause notices for each year. Because the notice issued, now one of the issues is they say the first initial years is not covered by 74, which is you don't have extended period. Now, how would we know unless you issue a separate show cause notice for each year, the show cause notice covers for which year? You cannot club the years. You cannot issue one notice for all 5 financial years, right? Because if you issue for each year wise, we may believe that the last 2 or 3 years, it may be valid. It may be covered within the limitation. Now we cannot partly quash a show cause notice. So therefore, there seems to be a lacuna in the issuance of show cause notice itself. How would you address that?
Lordship, I would just say that there might have been a factual error on the part of the respondents, but my lordship, the meticulous draft, the respondent, I am sure, must have focused on the meticulous drafting on the issues and as per drafting of so-called notices as per the issues rather than keeping in mind the timeline. So that is all I have to submit with respect to that, my lordship.
All right, your time is up. You can.
If I may please sum up in just 2 minutes, my lordship.
1 minute.
I
Sum it up in 1 minute.
My lordship, actually, I have one issue with.
All right, you finish it, whatever.
Okay,
the
my lord.
the time given, you finish whatever you want to finish.
Okay, my lordship. So, my lordship, the third issue is whether secondment arrangement in general is liable to GST or not. Lordship, the council submits that it is liable to GST as there has been a just a second, my lordship. My lordship, there has been a arrangement between 2 different principles, as in 2 principal authorities. To this, I would like to cite the judgment of Silver Jubilee Tailoring House, which talks about the master servant, and it says that the idea of master servant is a bygone era, is a concept of a bygone era. So basically, now what happens is that if a person or if an employee who wants to visit and if he wants to work and if he possesses skills, then the employer seeks for the skills. So basically here, the master was considered superior to the servant only because he possessed a greater understanding of everything. But here it is upon the skill that the hiring is being done. Therefore, both are at the parallel footing. Both are being mutually benefited. Therefore, there is some sort of arrangement, a service arrangement, agreement between both the parties, but it's not essentially a master-servant relation involved, and therefore they are two different entities primarily. And the same is the case here in secondment arrangement as well. Since someone is coming from, I'm talking about the expats, if they are coming from over the seas and they are coming to any country, then the skill, and here is the case is as well is that of skill, that they are highly qualified personnel who came. Therefore, there exists a secondment arrangement. Now, I would like to draw this honorable court's attention to the scope of supply. My lordship, section 7(1)AA under the explanation of supply talks about separate of the central of the CGST Act 2017 talks about separate entity, my lordship. So basically, it is legally established and statutorily established that the law sees them as a separate legal entity. So that is the point I'm trying to make here is that since the law talks and in the eyes of law, there are two different persons, then there doesn't exist an employer-employee relationship. Rather than two different personals are there, and therefore, and hence the secondment should be applicable in that.
Yes, some it, close it.
Okay, my lordship. So, as there has been one extended period of limitation also, my lordship. I have argued it. I have assisted the honorable court before about this. There has been willful misstatement, and lordship, the necessary requirement for issuing notice under 74(1) is fraud, collusion, or willful default. To this effect, I would like to bring honorable court's attention to Cosmic Dye Chemical versus Collector of Central Excise. I would request my lordship to refer to page 17 of the compendium.
You have passed it on, we will refer to it, you just point out the
Yes,
page and
so
point out the page.
it goes well with my contention, my lordship. That's all I want to submit. And the petitioners have the malified intent to evade tax, as I submitted before, and therefore there has been a deliberate default on the part of the petitioners. Thank you.
Yes.
May it please this honorable court. I'm the counsel 2. My name is Niharika, and I'm the counsel 2 for respondents. That is the additional commissioner of GST and others. The lordships, I will be dealing with issue number 4, 5, and 6. The issues, and I shall be proving to your lordships that firstly, GST will be applicable pre-2022. Secondly, GST will be applicable post the arrangement of 1st June 2022, and thirdly, that there is an import of service, and therefore GST will be applicable on reverse charge mechanism. May I begin with my submissions, Your Lordship?
No, we only want to appreciate your first sentence, the way you started. GST is applicable, will be applicable forever. Whatever may be the facts and circumstances. This is the proposition of law. All right.
So, Your Lordship, with respect to the issue 4, I submit that there is no contract of service between SOS India and the expats. Rather, there's a principal relationship between SOS US and SOS India. To support the same, Your Lordship, there have been various precedents that have stated that to satisfy who's an actual or the original employer, certain factors are to be considered. Looking at the factors, I shall point it out. Firstly, that right of lien of employment. Secondly, the continuation of employment. And thirdly, the social security purposes. Now, Your Lordships, I submit that with respect to the facts given, your effective and absolute control is with SOS US. Even if we refer to the hire and fire test, the actual and effective control is with SOS US. And for the same, I shall assist the court with the judgment of Target Corporation India Private Limited on page number 27 of the compendium. Your lordships, in that particular judgment, it had been stated that the right to terminate the secondment is not the right to terminate the employment. And therefore, your lordships, I shall point it out to you that SOS the right to terminate the employment. Moreover, your lordships, the had stated that there exists a double employment. However, 03 of subsection 3 of the Companies Act states that double employment of KMPs are not allowed. Moreover, your lordships, I stated in the beginning that there exists a principal relationship. Your lordships, I submit that there is SOS US is the holding company and SOS India is the subsidiary company. Now, both of these are separate legal entities and they share different resources. Since they share different resources, human resources is included in resources. Therefore, the employees are not under the contract of service, but there is a contract for service, Your Lordship.
What would you say was the nature of payment, regardless of this reimbursement? The expats, what they received from the Indian company, what is the nature of that payment is called? Would you call it as a salary or a consulting fee?
Your Lordships, the payment that the expats are receiving is salary, Your Lordship.
Salary. So in
Yes, Your
case
Lordship.
of contract of service, it is our understanding that it should be salary. In case of contract for service, it should be a consultancy fee. So if they have received salary, barring only the right to appoint them, the complete exploitation and extraction of the skill of these employees throughout has been by the Indian company. So it more appears it's safe to conclude that they can still be called as the employees of the Indian company itself.
Your Lordships, I submit that the fact sheet states that it is a salary, but however, para 11, if your Lordships could refer para 11, it is stated that there existed a contract of service between SOS US
Yes.
and its employees, Your
In case
Lordship.
of salary, that's what our understanding is also, that if it in case of contract of service, it's a master service relationship and therefore there is salary payment. In case of an independent contractor, there is a consultancy fee and therefore there is contract for service. So because it is a contract of service, which is supported by the fact that they were completely exploited by the Indian company, there seems to be a master servant relationship between the petitioner and the employees. So the underlying objective is to use them. That was the purpose of seconding them. So this argument that I had only the right to appoint, which was years ago, and this manpower supply may be on a thin ice. It appears that more likely that it was the Indian company which was acting like the employer.
No, Your Lordship, I beg to differ from Your Lordships. Firstly, I would also like to state that the petitioners had stated this judgment of Sushilaben Indrabhavan Gandhi, where they had stated that not one but a number of judgments are to be looked at to find the employer-employee relationship. Now, apart from the right to terminate, there are certain factors that are to be considered. That is the fact that the invoice that is being raised is by SOS US. The payroll contains the names of the expats that are being seconded. Moreover, SOS India is importing services from SOS US, and that shall be dealt in the sixth issue, Your Lordship.
Was there any profit to the US company in this arrangement?
Your Lordship, there is the fact sheet states that there's no profit to SOS US. However, indirect benefits such as
If it cannot be converted in terms of money, then what would your basis to tax? What is the tax base?
Your Lordship, deemed consideration, Your Lordship.
No, what is that amount in the sense? See, I mean to say that all the salary payments will be subject to GST. What is your tax base on which you will apply that 18%?
Your Lordship, the tax would be based on the deemed consideration. That is the invoice that is being raised to SOS US.
So we see a flaw here because you want to treat the salary itself as a consideration received by the US company. That is not the case. In fact, the US company had paid it to the employees. It was not retained by the US company. So we are on the valuation aspect that you cannot value, but maybe at best, maybe the first year, because even in case of manpower supply, It cannot be that the supplier will be paid his consideration every year. It's a one-time payment. Maybe for first year, the salary can be treated as a tax base. But subsequent years, how can you issue show cause notice? Saying that every year, as long as they continue as Indian employee, you would be paying GST. It is not an ongoing service. It is a one-time service, isn't it?
Your Lordships, for the same, I shall refer to CGST Rules Act, rule number 28, where it has been given that value of supply of goods or services or both between distinct or related persons other than through an agent. So, Your Lordships, to your answer, I state that SOS US and SOS India are related entities, and therefore the value of supply or the value of supply of services
At best, you may be correct in issuing notice for the first year. But I think it is extrapolating for all the years. I think it's far stretched. You cannot say all the salaries received by the Indian employees should be liable to GST by the Indian company under reverse charge.
Your Lordships, with respect to 1st June 2022, I shall prove this. That brings me to my 5th issue, if Your Lordships may.
We'll wait for that.
So,
Counsel, before you go to the other issues, I think each one of these arguments, the way you are indicating seems to be landing you more in problems. I'll tell you why. You said that the foreign company will raise an invoice on the Indian company, correct?
yes, Your Lordship.
Let's assume it is for $100.
Yes.
The payroll of the US company will show the amount to be $100, which is what is the salary that you paid to the expat who has come from the US company. Right. Now there is a commercial or economic exploitation of that person by the Indian entity. Correct? There's an economic exploitation by the Indian entity of that particular expat. Right. Now you said there is a deemed consideration.
Yes, Your Lordship.
On what grounds will the deemed consideration come in GST law? Have you seen that? When will deemed consideration come?
Your Lordship, I submit that since there is a lack of direct financial benefit between the SOS India and SOS US, there are indirect benefits that are being that is being received by SOS US, such as enhanced expertise or improved services, Your Lordship.
How do you quantify it? How do you quantify that benefit? You looked at Rule 28. Kindly see Rule 28.
Yes, Your Lordship.
How will it help you? That's what my brother was asking. How will you have a tax base for demand of GST if your payroll is only for the actual salaries?
Your Lord,
Invoice is also for the actual salaries, and the salaries is what is paid to the to the person concerned. What is the value on which you can demand a tax?
if Your Lordships could permit me 30 seconds for use this.
What does Rule 28 say?
Yes, Your Lordship. Rule 28 states that value of supply of goods or services are both between distinct or related persons other than through an agent. So the value of supply of services between distinct persons other than where the supply is made through an agent shall be the open market value of such supply.
One, is there an open market value? Look at it. $100 is what is being invoiced by the foreign entity to the Indian entity. Payroll shows $100. $100 is paid to the employee. Correct? So the entire $100 is treated as a salary. There is no other independent value. Now you are applying Rule 28. Where is the open market value for that service? Even if the expat, the foreign entity, is giving a service to the Indian entity, where is the open market value? There is no open market value. What is the next rule?
If the open market value is not available, be the value of supply of goods or services of like kind and quality.
Is there a like kind and quality available? Go to the next one.
If the value is not determinable under clause A or B, be the value as determined by the application of Rule 30 or Rule 31.
What is Rule 30 or 31?
value of supply of goods or services or both based on cost, your lordship.
Cost. So are you able to arrive at the value through a cost? The cost is zero. That's what my learned friend was asking. That if your cost is zero, the value is zero, then where is the GST on that?
Your lordships, to that point, I shall bring to your lordships the concept of import of service under Schedule 1, Clause D, which states that I shall read out to you. Your lordship, Schedule 1 states that the activities are to be treated as supply even if made without consideration.
No issues.
And
No issues.
And the fourth point states that import of services from a related person
No problem.
or from any of his establishments
Therefore, you
outside
can-
India.
You can tax it. We have no difficulty. How do you arrive at a value? Even if there is no consideration, you have to have a consideration. If your entire amount is only salaries, look at it post June 2022 or pre-June 2022. If the value is only $100 and if you don't have a value on which you can demand tax, then what are you after them?
The purpose of GST, introduction of GST or value added tax is input tax credits.
Yes, Your Honor.
You should apply your brain there. Any valuation difference will get taxed wherever the chain is discontinued.
If your lordships may permit me to come back to this answer after myself. Your lordship, may I begin my issue 5, which deals with the arrangement post 1st June 2022.
Yes.
Your lordships, for this particular issue, I shall deal my argument in a twofold manner. Firstly, I shall bring to your lordships' attention the principle of substance over form, and secondly, the principle of colorable legislation, your lordships. Now, your lordships, substance over form, the principle means that the practical essence, not the legal or the formal structure, is to be looked at. And for the same, I shall request your lordships to refer to page 29 of the compendium, where the judgment of Associated Hotels of India versus R.N. Kapoor is stated. Now, your lordships, looking at the facts, it is clear that the petitioner is trying to get indirect benefits from enhanced expertise and to provide improved services to SOS US. Moreover, the objective, as stated in the fact sheet, is that of value addition to their customers, which is SOS US and SOS India worldwide. Therefore, your lordships, I submit that still there is an element of control that SOS US holds. Moreover, your lordships, the point of colorable legislation, I state that what cannot be achieved directly should not be attempted indirectly, your lordships. Here, the petitioners are deliberately attempting to circumvent the GST implications. The true intention is to be looked at, and for the same, I request the lordships to refer to page number 46 and 47 of the compendium. It states that on page number 46, that the taxing authority is entitled and is indeed bound to determine the true real relation resulting from a transaction. If the parties have chosen to conceal by a device the legal relation, it is open to the taxing authorities to unravel the device and to determine the true character of the relationship. Moreover, in para number 22, it has been given that every person is entitled so to arrange his affairs as to avoid taxation. But your lordships, the arrangement must be real and genuine and not a sham or make-believe. Even the perusal of para 45 states, which the point of tax planning. However, the issuance of tax planning is done for future, your lordships. However, such retrospective issuance of employment letters contends that it is not tax planning. However, the retrospectively tax planning, which is a sham or a make-believe, is what the respondents would submit.
Yes, proceed to the next.
Yes, your lordships. with respect to the issue 6, I submit that issue 6 deals with the fact that there should be no GST implications on import of service. There should be implications on the GST implications should be there on import of service, and therefore they are liable under reverse charge mechanism. To prove the same, firstly, I shall refer to definition of related parties under section 2, subsection 76 of the Companies Act. Secondly, I shall prove to your lordships that the definition under import of service, section 2, subsection 11 of IGST Act, which states that firstly, for import of service, there should be a supplier outside India. Here, the supplier outside, there should be a supplier outside India, which is SOS India. Secondly, there SOS US, I correct myself. Secondly, there should be a recipient in India, which should be within India's taxable territory, which is SOS India. And thirdly, that the place of supply should be in India. And since the services are being utilized in India, that is, the resources are being utilized in India, I submit that the factors stated in import of services are being met. Now, the lordship shall, now the council shall also prove that for import of service, there should be a supply of service. To prove the same, I shall refer to section 7 of the CGST Act, which defines the scope of supply. There are two factors here. First, that there should be two separate legal entities. I had already established that there are two separate legal entities. Secondly, there should be consideration. Now, your lordships, referring to Schedule 1, as I did refer a few minutes back, there is an exemption under Clause D. Therefore, I submit that this is a deemed supply. Now, your lordship, since RCM is the liability, since liability to pay tax under reverse charge mechanism arises under, is on the recipient of the services, therefore, here the GST would be applicable on the basis of reverse charge mechanism, your lordship. Moreover, if your lordships are satisfied with my sixth issue, I shall begin with my prayer.
Yeah, go to the.
Therefore, in the light of issues raised, arguments advanced, and
One last question.
yes, your lordship.
Subject to my. Say we were saying that there was a judgment earlier and he wanted to circumvent those people. They wanted to circumvent the legal position. They wanted to defeat this, that, and all. Assuming a proposition of law is laid down in the judgment, and in order to circumvent the judgment, the parties arrange their affairs in a different manner. Say, instead of borrowing the services from there, they say, those who have been borrowed, they will be our employees. We have entered into a separate agreement with them. We need not have to show what agreement and all. They have no relationship with the previous company who had supplied them here. So they will be my employees. I am paying them. I am paying towards my contribution to PF. So therefore, even if this is devised to get over the judgment, is there any difficulty in accepting if otherwise it is legal? If otherwise the whole affair is legal, only because there was a judgment earlier, should we allow you to tax them?
So, your lordships, with respect to this, I shall submit that there are social security reasons as well. So, lordships, the employment laws that are, such as gratuity or insurance that had been brought before, your lordships, that is to be considered. That is the economic, that proves the test of economic reality, your lordship.
That's why we say, apart from that, antedating the whole thing, assuming that is impermissible, that was not. So far as the futuristic aspect is concerned, from the date of that 22.
1st June
2022. Why should you tax them? What is the if the facts glare at you saying that they are my employees, now the different system is put in place. They are no longer controlled by them. They are not answerable to the overseas company. They are my employees. I am paying them everything. And all right, you cut whatever you want to cut on the social security. I am prepared to pay for it. If that is their stand, how can you say for this period, at least for this period? How can you say? Because the earlier period prior to 17, they have already accepted and paid. Maybe from 17 onwards, there appears to be some confusion. But thereafter, from 22 onwards, what is the problem?
Your lordships, with respect to the experience letters that they had issued, I say that there is no retrospective application of these social security benefits.
No, post 22. Lordship wanted to know post 22.
Subsequent to 1st June
Yes.
22. That's fine.
The second show cause notice. What is your difficulty? Is it okay if we quash the second show cause notice? Because you cannot sit in the armchair of the SSE. So that they should subject to themselves to maximum tax. So probably it's a win-win. One show cause notice is quashed, other one is allowed. Would you agree to that? Are you okay to quash the second show cause notice?
Your lordships, in this case, I should bring to your lordships that there is tax evasion that the petitioners are contending. Therefore, if SCN second SCN is quashed, that will be
The
Oh,
first show cause notice is for first 5 years,
Yes, Your
17 to 22, where retrospective letter, all those that was done. Second one is prospective. So if they identify an employee, they bring it here. He gets terminated there, he comes here, freshly recruited here. There we see there is no tax evasion. So that is their arrangement. As Lordship said, it is their arrangement. Merely because there's a judgment, they need not follow the same way. They can arrange in a way which is not illegal. So we don't say any illegality post 22. What would your answer to that be? No specific answers, no problem. We may proceed to conclude.
All right. You need not answer that. We will answer you.
certainly, your lordship. May I begin with my prayer?
Yes, yeah.
Wherefore, in the lights of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to declare that the writ petitions filed by the petitioner be disposed of and declared as not maintainable, and pass any other order or judgment or directions that the court deems fit.
All right. What is the point? On what point you want to rebut?
There are 2 points in lordship.
Okay. Which are those 2 points? No, you go there, you can say. No, unless we need your rebuttal, unless you really want to highlight a particular aspect, and confine it to those aspects.
Certainly, your lordship. So as pointed out by your lordship, a single show cause notice cannot be issued for multiple.
Don't borrow our very ingenuity. You
That is
should
what-
have.
No, your lordship, this has been held in the case of Titan Company versus Joint Commissioner of GST as well.
That's fine.
Should have been your first one.
Yes, yes.
You're borrowing it from us. It's
So-
not appreciated.
So
The council apologizes
being
for
its
it.
rebuttal, don't re-argue
Yeah.
or emphasize on what the court said. Right? So if you have any new points based on their arguments, you can point it out. Otherwise,
Is that-
it's
Is
still
that-
fine.
Is that agreement part of this compilation? Is that decision part of the compilation?
For petitioner's compendium, it is there, your lordship.
Is there?
Yes. So the case 5, if your lordship may. So if the respondent has not answered on pertaining to why should that if the show cause notice in itself is invalid, since for multiple financial years, a single show cause notice cannot be issued, then why should an order that has been passed based on such an invalid show cause notice, why should the company comply with such an erroneous order? Secondly, your lordship, under 74 subsection 9, an order can be passed only pertaining to amount of tax, interest, and penalty. But in the written submissions that are provided by the respondents, they are calling upon the petitioners to face penal liabilities for their non-payment. Now, from where these respondents are deriving these powers, this is unclear because certainly the CGST Act does not provide these powers. That is all, Your Lordship.
Thank you. So we'll adjourn the court. Yes, we have heard you. Thank you very much. Court is adjourned. Thank you. Good.